Today's presentation is entitled Rent Abatement, Understanding Tenants' Rights to Habitable Housing in Milwaukee. This is one of the topics that's really common, commonly seen in the market balance legal clinics, really second to family law. I would say are questions related to money and debt, but within that money and big category of money and debt, housing issues are just front and center. And it seems like no matter how much infrastructure our legal aid partners build to really help addressing this, it's not going to go away anytime soon. So I'm glad we're going to be learning a little bit more today about tenants' rights in this realm of habitability, and what we can do to help people protect their right to safe housing. And maybe even answer the question, do they have a right to safe housing? Today's presenters are from the Legal Aid Society of Milwaukee, Josh Cather and Mitchell Yurkowitz. Josh attended Marquette University Law School, and he practices landlord-tenant law at the Legal Aid Society of Milwaukee. He's on the housing team there. Mitch is also an attorney at Legal Aid, and he has over 4 years of experience representing tenants in eviction cases. Thanks both for being here. We look forward to learning from you, and I'm going to turn it over to you now.
All right, awesome. Again, my name is Mitchell Yurkowitz, attorney with the Legal Aid Society of Milwaukee on the housing team. I've been doing eviction work for a long time. And then as part of that, abatement is a very, very big part. So I'm happy to be here, excited for this CLE, and I'll turn it over to Josh.
Hello, my name is Josh Cather. Like Angelo said, I am a staff attorney with Legal Aid Society of Milwaukee on our housing team. I've been a member of this team since I graduated law school from Marquette back in May of 2023. We are going to go over rent abatement, or reducing the rent, the statute that gives tenants this right, and the best approaches in Milwaukee courts from a tenant's perspective. The CLE will primarily be focused on the process in Milwaukee County. Next slide. All right, so we will be looking at Wisconsin Statute 704.07. This deals with repairs and untenability. The statute as a whole is somewhat convoluted. Hopefully, after the CLE, it makes a little bit more sense. If you've looked at the statute before, if you've never looked at it before, hopefully you have an understanding after the CLE of what it means. There are two sections that we're going to primarily focus on. Subsection 2, which outlines the duties of the landlord as far as habitability, and subsection 4. Subsection 4 is what gives tenants the right to pay unabated or a reduced rent if the circumstances of the condition issues are met. I'm going to go over those circumstances in just a little bit. Okay. So, looking at the statute, I do just want to briefly go over each of the duties of the landlord. So, the landlord has a duty to, number one, keep in a reasonable state of repair portions of the premises over which the landlord maintains control. There's a duty of the landlord to keep all equipment in reasonable state of repairs under the landlord's control, such as heat, water, or air conditioning. The landlord also has a duty to make all necessary structural repairs. Subsection 4 is not as relevant in Milwaukee because in Milwaukee County, we do have a residential tenancy housing code, so we would be looking at subsection 5. There's a lot of overlap. For instance, a hole in the roof that could fall under subsection 1, keeping a reasonable state of repair portions of the premises over which the landlord maintains control. I think that would also fall under make all necessary structural repairs. The statute does a good job of covering most of condition issues, and it should fall ideally under one of these categories if there is a breach. Subsection B, I do want to touch just briefly. If the premises are damaged by negligence of another tenant, so let's say you have a multi-unit property, a ton of tenants living in there, one tenant causes a condition issue, the landlord still has a duty to those other tenants to keep the habitability up. BM, I also want to touch. There are already condition issues before the tenant moves into the property. The landlord has a duty to disclose these issues to the tenant before they move in. If they don't do that, that could subject the landlord to an ATCP claim, subjecting the landlord to double damages. We're going to talk a little bit more about the ATCP later on in the presentation. This is an example where not every condition issue rises to the level of abating rent. Also, not every condition issue may be the result of the landlord's breach. Looking at subsection A, this covers that scenario, because sometimes the tenant may be responsible for the condition issue. In circumstances like that, the tenant would not be entitled to paying a reduced amount of rent. In fact, the tenant is likely responsible for fixing the issue, and if they don't fix the issue, they could be subject to an eviction. Next slide. Another example where maybe the tenant caused the issue. If the tenant caused the issue here, it would be their responsibility to fix the window. It wouldn't be the landlord's duty necessarily. Now, they might have a duty to the other tenants if this window was, for instance, causing extremely cold temperatures. They might have to fix the issue because they do have that duty to the other tenants. Okay. Again, when we're looking at rent abatement, we want to start with subsection 2 of Wisconsin Statute 704.07. If there's going to be a defense based on abatement or a possible claim for money that's owed based on abatement, the first step is finding a breach of one of these duties. Like I said before, in Milwaukee County, we're likely looking at these four, as subsection 4 covers locations where there are not local housing code. Okay, so we've established the duties of the landlord. If the landlord breaches that duty, we get to subsection 4 for the remedy. I believe this subsection can be broken down into two parts. What gives the tenant a right to vacate with no further liability? So a tenant on a lease for 1 year, let's say in the second month of that lease term, a condition arises. I'm going to go over the wording specifically, but they would no longer be liable for the remaining 8 or 9 months on that lease. The highlighted part outlines what is necessary for a tenant to vacate without any further liability. So, if the premises are damaged by a fire or because of any condition hazardous to health, or if there is a substantial violation of subsection 2 and that condition issue materially affects the health or safety of the tenant may remove from the premises unless the condition issue is promptly addressed by the landlord. In other words, in order to move out without any further liability based on the condition issues at the property, there must first be an event like a fire, or, more commonly and relevant to our presentation, a substantial violation of the landlord's duty under subsection 2, and the condition issue materially affects the health or safety of the tenant. If there's a substantial breach of subsection 2 and the issue materially affects health or safety, if the landlord is not prompt about addressing that issue, the tenant can vacate and the landlord shall repay any rent paid in advance at that point. That would also be referred to what's called a constructive eviction. Again, a constructive eviction is covered under the ATCP. We're going to touch more on that later on, but this would give rise to a claim potentially for double damages as a result of a violation of that ATCP rule. Yep. Okay. Okay, so if the tenant decides not to move or the tenant cannot move, and I want to mention that moving is very expensive, especially for a lot of the clients we see here at Legal Aid. Um, Most of the time, it's requiring a double security deposit, first month's rent. If the tenant just moved into this property and now they're forced to move, they likely do not have the money that's needed to move. I also don't believe a tenant should be put in a position where they either have to move because of the condition issue or they live with the conditions. Subsection 4 does address this scenario. So, if the tenant cannot move, or if the condition does not rise to the level of materially affecting the health and safety, what can the tenant do? If the tenant remains in possession and the condition issue materially affects the health or safety, or substantially affects the use and occupancy of the premises, rent abates to the extent the tenant is deprived of the full normal use of the premises. I want to note that in order to vacate, a condition issue must rise to materially affecting the health or safety of the tenant. But in order for rent to abate, it can either materially affect the health or safety of the tenant, or the condition issue substantially affects the use and occupancy of the premises. So there's a higher burden necessary for a constructive eviction where you are able to move out without liability, whereas rent abatement, if the condition issue doesn't affect the health or safety, but it does in fact substantially affect the use and occupancy, the tenant should be entitled to an abated rent.
Your colleague is posting a question asking if you could maybe give some examples of this.
One second. Yeah, so examples of condition issues, or would this be more an example of a breach? Um, as far as a constructive eviction goes, a condition issue that um, materially affects health or safety. I think in the winter months of Wisconsin, if you had no heat, for instance, that would be an issue that would give rise to a constructive eviction where the tenant could vacate without any further liability. Um, Severe infestations, I think, could rise to this level as well. Um, Whereas a condition issue such as a screen's not working. Certainly, there may be arguments that not having screen windows would affect the health and safety, but let's say it's only one window. I think it would more likely rise to that level of affecting the use and occupancy, substantially affecting use and occupancy, but one screen window may not rise to the level of materially affecting the health or safety of the tenant, meaning the tenant could abate rent, but they might not be able to just get up and move without any further liability.
Some other specifics have been posted now in the chat. For example, what if there's lead-based paint and that's affecting only a child in a household but not the adults? What about a toilet that won't flush unless you need to use a bucket of water? What about, is it a health and safety is health and safety an objective standard or subjective? And what about mold, sewage backup due to plumbing? Lots of lots of wanting some fact specific analysis here.
Yeah, so let me just mention that there's not a lot of case law on this issue. I'm going through the statute. There's not a lot of definitions as far as what is substantial, what is material. Um, we really are doing our best at kind of defining those things through court and our practice. I think it is one of those things where you want to be confident that you could argue how this affects your health and safety. Um, Mold is really tricky in Milwaukee, and we could talk about every condition issue and whether I believe it would rise to the level of abatement. But I do think the challenging part with this statute and the fact that we don't have a lot of case law, we don't have a lot of local um, procedure or ordinance on abatement. It's really got to be a situation by situation, and you want to be able to support if the tenant does decide to vacate, why it affected the health and safety of the tenant or tenants. Lead and mold are both issues with that are tricky. A lot of times, mold is the result of some other violation, and that's commonly what the Department of Neighborhood Services will say when they come by to address a potential mold violation. They typically will actually give a violation for some sort of leaking pipes. Lead gets a little bit tricky as well because a lot of tenancies require the lead disclosure forms. I don't believe that should be dispositive from any potential claims related to lead. But lead is one of those things that you want to definitely have tested. You'd want to have evidence that the lead exceeds the limits, which I know are probably higher than they should be, especially when dealing with children. Um, but lead should be something that rises to the level of allowing for rent abatement for sure, but a constructive eviction where the tenant can vacate. Mold is tricky, especially because a lot of the clients we have believe mold to be black mold, which really you would want someone to come in and actually test for that specifically.
And not to pass the buck on those two particular issues, but for mold, or I'm sorry, for lead, Department of Neighborhood Services has a lead abatement, not rent abatement, but abatement meaning to end or to reduce a lead abatement uh, uh, program in order to basically help get lead out of homes. And so that would be one place to start with that. And then the other thing is that I also tend to start with basically, and we'll get to this later, but the Madison Code of Ordinances, they have an abatement chart. I usually start there. If it's in there, I think it's good enough. If it's not in there, I I would. I'm not saying it's not. I'm saying I'm gonna do a little bit more work on it. So that's usually where I start from. Something like a toilet not being able to flush, that's absolutely in there. Mold, that's in there. A sewage backup is probably, I believe that's in there. So that's usually where I start from and kind of go from there. Obviously, that's Madison. It's not Milwaukee. None of that's dispositive here. However, we're trying to kind of get the courts to accept that a little bit more. So I really would recommend doing that. As far as factors that the commissioners look at, we will absolutely be getting into all of that shortly.
One other thing I'll just pipe in to say for the group is that there is a folder in our gold guide. So for our active volunteers, I'm sure you use the gold guides probably on a consistent basis. They're the law that we see most commonly in the clinic. And in the gold guides, in the landlord tenant folder, we do have an abatement itemization calculator that was just developed by these very folks we're hearing from. And there is, I think, also that abatement itemization list that Mitchell is referring to. Yeah, it's here. It's available for people to look at. So if you're coming across this in a client you're working with, there are tools available in the folder for you to rely on. And actually, while I'm talking, I know it's only 12:20, but I might as well just go ahead and read the first part of our attendance code. So lawyers on the call, you want to make sure that you pull out our attendance form to submit your attendance for this session. Students, you don't need to submit any forms. You just need to record your pro bono time for participating in today's session. First part of the code today is the word nice. 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 Okay, back to you all.
Okay. And I did just want to again say, I think somebody asked if it's an objective or subjective standard. It's a great question. I would say it's a subjective standard for sure at this point. We don't really have anything defining these things. Um, and now I can, I believe, move on to the next slide. Thank you. All right. So we have the landlord's duties in subsection 2 of Wisconsin Statute 704.07. If there's a substantial violation of those duties to repair, we look to subsection 4 for possible remedies. Higher burden to vacate compared with abating rent according to the statute. Next slide. Okay. So let's assume we have a breach of the landlord's duty. That condition issue has not been addressed and the tenant continues to remain in possession. The tenant should be entitled to an abated rent, but how much should that abated rent be? Milwaukee does not have an abatement schedule or an ordinance specific to rent abatement. We would refer back to the statute. The amount abated should equate to the extent the tenant is deprived of the full normal use of the premises. Again, I believe this to be a subjective standard. Most housing attorneys, like Attorney Yerkowitz mentioned, will refer to the abatement schedules from other cities to show that the amounts being abated are reasonable or proportional to the deprivation of use. Madison and Wausau have abatement schedules. We tend to lean on those schedules when we go to court and argue abatement. Here's an example off the Madison City Ordinance abatement schedule. As you can see, Madison creates subcategories of each condition issue, and they also have ranges of percentages. So not every condition issue is the same level of severity. Infestation is another example here where certainly if you have a mouse every other day and you're putting up traps, you probably do have an infestation issue. Now, I've also seen tenants that have multiple mice and cockroaches every day they put down rats. Certainly, the infestation for the second tenant is a little bit more severe than the other tenant. Providing ranges of abatement percentages makes sense. Having subcategories that are more on point for the specific condition issue makes sense. I wish Milwaukee had one of these because it certainly would support our arguments a little bit more on point. But like Mitch Yerkowitz said, we rely on Madison and Wausau for the most part currently. Okay, so there's one more clause in subsection 4 that I think is really important and crucial. And I don't think it's as straightforward as it may appear. So this section does not authorize rent to be withheld in full if the tenant remains in possession. I believe this clause means that as long as you hold possession, there is some amount of rent to be paid each month. However, I don't believe this clause should be dispositive on every eviction case where the tenant does not pay any rent for a given month. And I'm going to explain that in just a couple slides. I also want to mention that the statute references both abatement and withholding in that clause. Rent withholding in Milwaukee is a completely different mechanism to getting the landlord to fix condition issues. Rent withholding is done through the Department of Neighborhood Services. It requires code violations, and the rent being withheld in a lot of cases ends up being dispersed to the landlord. Whereas abatement, on the other hand, which is based in the statutes, is rent that is not owed. So the abated rent is never paid to the landlord. It's just reduced when there's a breach of subsection 2, and it either substantially affects use and occupancy or materially affects health and safety. Okay. This is actually brought off of the City of Milwaukee website. It does a good job of kind of distinguishing the two mechanisms of rent abatement and rent withholding. Truthfully, I believe the withholding term in the statute essentially equates to no rent or no condition issue abates 100% of the amount of rent. Okay, so broadly speaking, if there's an eviction filed and there are serious condition issues involved with the property that the tenant's been dealing with and the landlord is aware of, if you're going to contest the eviction part, the first cause of action, you want to show that the alleged breach, likely based on a 5-day notice or a non payment of rent, that's really when an abatement defense would be relevant. As an rent was not owed, the tenant was not in breach as an operation of law under Wisconsin Statute 704.07 sub 4. If the tenant does not pay any rent for a given month, but the abated rent over the course of their tenancy exceeds the breach amount, the clause about withholding in full should not be dispositive on the case. And I think the reasoning is actually somewhat straightforward. If you can show the tenant's abated rent exceeds the amount alleged, nothing was in fact withheld as the rent was not owed. In order to get an eviction judgment, most times it requires a proper notice and termination of tenancy is necessary before an eviction judgment is granted. In order for the court to find that an eviction judgment should be granted, they have to find that the tenancy was terminated. I don't believe the court can both find that the tenant was not in breach when the 5-day notice was given, and because they didn't pay any rent, they should be evicted. That's not how the statute works. And I don't believe tenancy can be terminated for breach if the tenant is not, in fact, in breach. Okay. Hypothetical one. I'm going to go through both of cases that we get that we have a high success rate, and then cases that we get where unfortunately we're not having as high of a success rate. So, hypothetical one. Let's assume the landlord breached their duty here by failing to address a hot water tank issue. So the tenant enters into a rental agreement on January 1st, 2026. On March 15th of 2026, the hot water tank goes out. Tenant notifies the landlord immediately, but the landlord takes no action. On April 1st, when the rent is due, tenant pays 75% of the rent. And that 25% reduction is found in the Madison and Wausau abatement schedules. Landlord gives tenant a 5-day notice for the non-payment of 25% of the rent, or $250 per the rental agreement, and files for eviction. So, if we were representing that tenant, we would argue that landlord breached their duty by failing to address the structural issue. The issue substantially affected the use and occupancy. Not having a water tank likely means you can't take a shower. All the family members potentially can't take a shower. I think over an extended period of time, there may be an argument that this would affect the health and safety because of unsanitary conditions. But for the purposes of this hypothetical, the landlord breached their duty by failing to address the structural issue. That condition issue substantially affected use and occupancy. Tenant paid and abated rent per the statute. Don't have to worry in this hypothetical about the withholding in full because the tenant paid a portion of the rent for the month that the landlord is bringing the eviction action over. That tends to be pretty successful in Milwaukee courts. Mitch Yerkowitz is going to get into the processes for making that the best argument possible. But for the purposes of the hypothetical, that first scenario is what are is what leads tenants to have the highest success rate when defending the eviction part of the eviction action. Next hypothetical. Okay, so tenant enters into a rental agreement on January 1st, 2026. On March 15th of 2026, the hot water tank goes out. Tenant notifies the landlord immediately, but landlord takes no action. From April 1st, 2026 to July 1st of 2026, no action is taken by the landlord, but tenant continues to pay 100% of the contracted rent. Again, in this hypothetical, landlord breached their duty by failing to address the structural issue. The issue substantially affects the use and occupancy. Rent abates at that point, meaning between both hypotheticals, an interpretation of the statute, rent abates at April 1st of 2026 in theory. In this hypothetical, though, the tenant didn't pay an abated rent, and when August came around, very common with a lot of our clients that we see, they get fed up with the condition issues and they decide they're not going to pay any rent for that month. Landlord gives a 5-day notice, brings an eviction action. It's our job to represent the tenant. I do believe this argument should still apply, but in this case, the tenant was still not in breach when the 5-day notice was given, even though no transfer of funds was given to the landlord for August. The tenant is not in breach as they had already paid the rent amount for August. So again, between the both hypotheticals, the rent should abate at the same point, but in the second hypothetical, the tenant pays the full contracted rent, but the rent, in fact, should be $750 starting in April. The tenant paid $1,000 for April, May, June, and July, when the abated rent should have been $750. $250 from all 4 of those months in excess of what the rent should be as an operation of law under 704.07. The tenant didn't withhold any rent in August. The tenant had already paid the rent for August. Again, that should make the notice insufficient if you can convince the court that rent should have abated back in April. Unfortunately, that's not the case. Most of the judges and even the commissioners, at least in Milwaukee County, tend to say that the tenant abated improperly or withheld improperly. Fact of the matter is, in Milwaukee County, again, we don't have an abatement ordinance. So we look to the statute, and reading of the statute, there is no proper way of abating rent. So I'm not sure improper abatement is even correct. Okay, what I just described in this hypothetical, where the tenant makes a claim later on and maybe wasn't actively paying an abated rent, is referred to as retroactive abatement. I'm going to pass this over to Attorney Yerkowitz for the rest of the presentation.
All right. So, yeah, getting into retroactive abatement, and we have that in quotes for a reason. Basically, the argument is that you're not abating your rent retroactively. All you're doing is saying that the rent that was owed for previous months was this much. Although we're going back and looking at those months where rent was maybe paid in full, we're really just accurately saying how much the rent was for those previous months due to those conditions issues that existed maybe while the tenant was paying the rent in full. So this is also a very common thing on the second and third causes of action. I'll briefly get into that in just a sec, but basically, once the tenant has vacated the premises, in an eviction case, That's the second and third causes. That's the money part of the case. The first cause is dealing with whether or not the tenant can remain in the unit. The second and thirds is about the money owed. For this, it makes a much better argument to the commissioners and to the judge, because we don't have to work as much with the rent cannot be withheld in full part of the statute. Basically, you're just reducing their rent burden. Some very important case law to be aware of on this: Bolter v. Shantz. This case was about a tenant who had like electrical issues with their I'm trying to remember exactly what it was, but it was an appliance, and basically the court said that the abatement could extend back to the date that, or at least back to the date that the landlord had notice of the problem with the appliance, and basically confirmed that retroactive abatement is a remedy. And then this Raymaker case is important to understand. We think that there's a lot of ways kind of around it. It's a very weird case where a tenant had like fallen off of a ladder and was suing um, the landlord for essentially allowing this broken ladder to be on the property. Even but the landlord wasn't aware of it, right? The tenant never told the landlord, hey, the ladder's broken or anything like that. And that's mostly what that case hinged on. There's a lot of arguments about what that case actually means. But the basic idea is the retroactive part of this can basically go back to whenever the landlord was notified of the issue. And again, as I mentioned, the second and third causes, that's the rent and damages part of an eviction case. And I'll kind of keep going. So the rent and damages part, when this is after the first cause of action. This is after the tenant has moved out. The landlord is now seeking the back rent or for any damages that the tenant may have caused to the property. There are kind of two ways to think about abatement. The first one is basically as a defense. The tenant or the landlord is saying that the tenant owes all of this back rent. But we're arguing that actually their rent burden is lower than that due to the abatement, due to the conditions issues. Because their heat was out, they don't owe rent for that week, or maybe they owe 50% for that week, or whatever it was. And all we're doing here is we're just reducing the rent burden. We've also raised abatement as an active counterclaim, basically saying, that maybe the landlord's only asking for $1,000, but this person was dealing with such extreme problems for so long. They had been living there for 3 years, just putting up with it because they had nowhere to go. You actually are then seeking not just the rent that the landlord is seeking to be, brought down to zero, but actually saying the landlord owes me back some of the money that I had paid to him previously. And again, because this is on the second and third causes of action, the tenant is already vacated. We're reducing a lot of risk at this point, so there's not the risk of eviction, and so we're able to make, I'll say, more aggressive claims. And the best practice here is to make that counterclaim affirmatively in advance in writing, and as well, we'll go into a little bit more about best practices there as well. A couple of different more things to have a good understanding on. Josh's abatement subsection is obviously the biggest one, but there's a lot more in the ATCP 134, as well as some other stuff with 70407. Basically, I'll get into each of those things in the ATCP a little bit more specifically. As far as the breach of contract claim, part of the idea behind abatement is there is the statute, but also you agreed to pay for the place that you're living in, right? And you agreed to pay for it at a certain level. If that level is significantly reduced, or if the conditions are reduced, if the conditions get worse, you're no longer getting the thing that you contracted for, right? So in a way, it almost stems out of contract as well as the statute itself. And then the damages that would be there is the abated rent. So it does make some sense, I think, logically, beyond just like the statute itself. And we will get into that a little bit more. So the ATCP 134, ATCP stands for Agriculture, Trade, and Consumer Protection. Obviously, this is more of the trade and consumer protection rather than the agriculture part. And then as well, the one thing I want to mention here is the Department of Agriculture, Trade, and Consumer Protection. They also handle some landlord-tenant complaints at the state level. Um, I don't know how familiar people are with the with Barada properties, but the DOJ ended up doing some investigations, and there was a settlement there. I don't ask me to recite any of the details there, but it stemmed from tenants making complaints to the DATCP about their practices. They're a little bit more focused on I'm going to call them trade practices, right? Like bait and switch and things like that, illegal fees and leases. But if your tenant is dealing with issues with their landlord, sometimes making a complaint with DACCAP can at least help, or at least notify the landlord, hey, somebody's watching you, basically. This is also an important part of understanding, basically getting the best leverage that we can after the tenant has vacated. So a security deposit means the total of all payments and deposits given by a tenant to the landlord as security for the performance. Uh, uh, Give me one second here. Performance of the tenant's obligations, and includes all rent payments in excess of 1 month's prepaid rent. So as we were talking about earlier, right, the idea of rent abatement is that the rent abates. The rent is less. If the rent was 1,000, it's actually 500 because of these significant condition issues. If the tenant was paying this 1,000 level, well, that extra 500, that is a prepayment in excess of 1 month's prepaid rent, right? And so that actually is security deposit when the tenant moves out. The reason why this matters and is a big deal is, one, the landlord has to return security deposit to the tenant. And two, if the landlord doesn't return the security deposit, that is a violation of the ATCP, and can lead to and violations of the ATCP can lead to double damages as well as reasonable attorney fees. So this is a major point of leverage for tenants after they vacated. Basically, look, hey, if you didn't pay me back what due to these conditions issues, and I can raise this, it can actually result in some pretty significant financial detriment to the landlord and benefit to the tenant. Let me get back here. Again, this is kind of going back to same idea that we've been kind of harping on for a long time here. The withholding from return of security deposits, this unpaid rent for which the tenant is legally responsible. Our argument is that if the rent's abated, they're not legally responsible for it. So that has to get returned to the tenant. The tenant is only responsible for the rent that they are legally responsible for. And one other thing that I want to just point out quickly here, that the normal wear and tear, a tenant is only responsible for the normal wear and tear. They are not responsible, or I'm sorry, excuse me, other way around. The tenant is only responsible for damages beyond normal wear and tear, right? They are not responsible for normal wear and tear, and that cannot be deducted from their security deposit. Sometimes this even landlords will try to even flip this around on the tenant. Well, they basically will say, the tenant complained to me about an issue, and then they'll basically use that as like the tenant caused this problem, and they're responsible for it. So just be on the lookout for that. And also the other thing with normal wear and tear is a lot of times landlords will try to charge for things like carpet, but the person would live there for 5 years, or it hadn't been replaced for 5 years before they moved in, or something like that. So make sure that you're aware of the normal wear and tear, and being on the lookout for that. In some circumstances, they might be on the hook for the carpet or the walls or something, repainting. But the tenant is not responsible for a landlord's desire to upgrade their unit. They're only that's not something that a tenant can be held liable for. The other thing that's important to note for security deposits, a landlord must deliver the security deposit less any amounts within 21 days. So starting on day 22, and by within 21 days, what I mean is 21 days after vacating. That A, B, and C, we get into a lot of arguments about that. So I'm not going to go into those exactly what it means for when a tenant vacates, just because it's going to take way too long to get into all of that. But the idea is basically the landlord has to send it. The circumstances where we see this the most is where the landlord doesn't send the security deposit letter at all. So they fail to send anything. They have to send the security deposit letter to the tenant no matter what, even if they're not entitled to security deposit being returned, or if they don't give the landlord an address to mail it to. The landlord has to mail it to their last known address, which granted would be the place that they just left from, but they still have to mail that. And for the record, a lot of times tenants may not get the letter, but the landlord did send it because it went to their last address. But this is a requirement of the statute, and if they don't, again, that's a violation of the ATCP, can result in doubling of that security deposit, because those are the damages that the tenant incurred. Is basically they didn't get that security deposit returned. So the important thing to look out for if a tenant comes to you and says, I didn't get my security deposit back, I didn't get a letter, be on the lookout for that. Or if they did get the letter, making sure that it's within 21 days after one of those A, B, and C. Again, we get into lots of arguments about exactly what that means if a letter is actually sent, but definitely don't have time for that today. Disclosure requirements, again, Josh had kind of mentioned this previously, but the landlord does have to disclose building code violations to tenants prior to moving in. One thing that I want to just kind of point out is this a little bit of it just makes it a little bit easier to uh, I'll say argue certain things just because it specifically is calling out not being able to, or not having heat in excess of 67 degrees, not proper electricity or proper components here. Again, I don't know how much people are aware of fires in a lot of Milwaukee, and a lot of those are caused by electrical issues. So, having a broken outlet or something, or not having outlet covers or whatever, it may seem like a minor issue, but in reality, it does affect the health and safety, the safety of a person and of the people in that unit, because it can very easily lead to electrical fires. Let me keep going here.
Mitch, do you mind if I interrupt with a question? This is actually
Absolutely.
my own question is just it sounds like we're always thinking about this in terms of presenting defenses once an eviction has been filed.
Yes.
And it sucks when an eviction's filed because then you have an eviction filing on your record, even if it's ultimately dismissed. But is there talk among all of you doing this work consistently about just affirmatively suing in the first place before an eviction is filed?
Let me skip to that
Okay, cool.
here. I'm sorry about that. I'm now checking our time here. So really rent abatement should be something that happens while the tenant is living there, ideally. The first thing that a tenant is going to want to do is document the condition, take photos with timestamps. The next step is going to be to contact DNS, or whatever organization is in that area, and then reaching out to the landlord in order to get that condition issue kind of going, right? With that Bolter v. Shantz case that we talked about just briefly, that a tenant, excuse me, the abatement can really only start once the landlord has been informed of the issue. I don't think that's technically correct with the reading of the statute, but as a matter of fairness, it does kind of make sense here. So one of the things that we have been working on is essentially a form letter that in order to help tenants abate their rent while they are living in the unit with these conditions issues. So zooming in on that letter, dear landlord, I'm a tenant residing at this property. I'm requesting that you address the following issues at the property that I'm renting. Listing those issues, whatever it is, heat, infestation, all those things that we've been talking about. These issues have affected my health safety ability to use the property I'm renting in the following ways, and then briefly explain how the tenant is impacted there. And then I have attached documentation detailing the extent to which I've been deprived. That documentation, you're going to be looking for those pictures, right? As well as just anything else that the tenant might have showing how they are deprived, right? As well as an abatement chart, which I will get to in just a bit here. And then again, asking the landlord for a 12-hour notice because 12-hour notice is required under the ATCP. if I don't hear from you in 7 days, I will begin abating my rent. So this is a letter just informing the landlord, hey, I'm having these problems. You need to come fix these. If you don't, I am going to start abating my rent. I also don't think that this is technically required. It's also best practice, right? For most of our clients, especially, they don't necessarily want to move. They just want to live in a place that is habitable. And so, giving the landlord an opportunity to repair things, I think, is best practice. Also, just a matter of fairness. And a lot of commissioners and judges, they'll be like, well, you didn't let them know. They didn't give them a chance. You have to give them a chance. So I do think that it's certainly best practice to do that, and then also informing the landlord about the tenant's rights under that retaliation is prohibited under Wisconsin law. I believe I had this here. Retaliatory eviction: no landlord shall terminate a tenancy because the tenant did any of these things. Reporting to a housing code. So a tenant should feel comfortable reporting their landlord to Department of Neighborhood Services, the tenant union organization, as well as the asserted or attempted any right specifically accorded to tenants under state or local law. That would include this rent abatement, right? So a landlord is not allowed to constructively evict a tenant, to refuse to renew a lease, any of those things, because a tenant reported them or has started abating their rent. Now, this is obviously not the case in 100% of cases. It's important that if you're helping tenants that are attempting to abate their rent, that they understand the risks involved with the potential that a landlord might try to evict them anyways, even though that's, I think, pretty clearly prohibited. Landlords will lie about the reasons, right? They might say that, well, I need you out in order to fix the problems that you're complaining about, right? So there are always risks. And also, it's pretty difficult to stop somebody from filing a case in the first place. You might be able to win it eventually, but just the risk of having that eviction open is a big deal for a lot of people. And getting it off their name is also a big problem too. Let's see here. Let me keep going on this letter. So this would then be the follow-up letter after if a landlord failed to address those concerns. Despite our previous communications, these concerns have not been addressed. I will be abating my rent. I will be abating my rent by blank dollars and shall pay blank dollars per month until the repairs are made. So again, pretty similar. And then again, also giving the landlord an opportunity to try to repair them, even though I'm abating my rent. And then once the landlord does repair it, you can't abate your rent moving forward. Ideally, this should incentivize the landlord to repair those problems if they want to get that full amount of rent moving forward. This is a communication log template that I'd really recommend that people try to use and try to get tenants to use. A lot of our tenants, they don't know how to document things well. They're not lawyers, right? So they're not thinking about that when they're just dealing with the problem, right? It's not their fault at all. But this can help them to think about it, as well as just having that log, having that exact date and time, and especially with things like phone calls, right? Because it's really hard to go back and get those later. Text, emails, yeah, it'd be great if tenants always had this text. A lot of times we got clients where it's like it was on my old phone, right? And they can't get it out. So at least you would have a record of something here. Let me keep going here.
We also have one more question in the chat. Oh,
Yeah.
and Josh has answered it in writing. So that's
Okay. All
great.
right.
So go ahead.
I know we don't have a ton of time here, so let me just kind of go through this quickly. So here's an example: moderate rodent infestation. Heat was out for a week, and then the tenant says that mold is causing health problems, and what you might be doing in those situations. So first, you go to the Madison abatement schedule, look at the extermination. I said that it was a moderate rodent infestation, right? So moderate, somewhere between severe and chronic, right? They're finding droppings in the kitchen. Tenant has to throw away food, kind of somewhere in the middle there. And so I picked the 10% number. I tend to go conservative while the tenant is still living there. After they moved out, I don't want to say go crazy, but you can be more aggressive. While they're still living there, really this is supposed to be an incentive and it also depends on what the tenant situation is. If they want the thing repaired and want to stay and want to maintain a good relationship with their landlord, being conservative with that might be the best option. At the same time, though, like they are entitled to this. This is something that just happens as an operation of law. So that 10% number, even though it might be less than the full amount that they could, still might be the best number to choose here. Heat was out for a week in October. They remained in the unit, and the only documentation is a text from the tenant saying, "Please come fix the heat." We're gonna get a lot of you get a lot of cases where there's not great communication, but that also is enough, right? Enough is also not best practice, right? So, kind of towing that line, informing them, hey, moving forward, this is the best way to document things. Do it in writing, do it in a somewhat formal manner, an email, whatever portal you have to make an official request for a repair, something like that. That might be the way to go. And then so with the heat, this is again the Madison abatement schedule. No heat or consistently below 55 degrees. Well, the tenant's not sure how cold it was. It was really cold, but to get below 55, I would want something like a thermometer or some kind of reading saying that it's actually below that, probably. But also it's October. Can kind of make a guess, right? So the inadequate heating might be the better one here, but also is only for a week, right? So even though the percentage might be 20% or 5% or something like that, because it was only a week, you do a quarter of it because it was only 1 week, right? So maybe you're only abating 5% there, but maybe it should be more. Maybe it was a week, but it was you basically couldn't live there. Or you were wearing a coat the whole time, right? It just depends on exactly what the context is, and it's important also to note that this is a one-time thing. It's not going to happen moving forward, or you can't abate for it moving forward. Tenant says mold is causing them health problems, but there's no medical documentation. So in the Madison ordinances, they have different options, mold in the dwelling, but it's not causing documented health issues. So that might be versus documented health issues, and then so severe that it actually is ordered unsafe by the health department or something like that. So really that 5 to 10% is probably best for now. But if you get documentation later, they could increase it depending on what's best for their situation. Again, another thing we see a lot is just mold in the basement, right? So maybe this is the better place to look for that. Basement, it's going to depend on whether or not it's a habitable basement. So that 6% number might be the best number to pick. It's going to come down to the exact person, your exact circumstances, what proof they have. If they have really good documentation, maybe you can go a little bit more aggressive. If the documentation's lacking, I might go a little bit more conservative, just to keep the tenant safe. And also, what is their risk profile, right? If they have somewhere to go, they got somewhere to move to, maybe you can go a little bit more aggressive. If they have no family in the area and they don't know where they would go and they need this place desperately, then maybe the more conservative option. That's not fair at all, but it still might be the best option.
As we're in the last minute here, I'm just going to
Yeah.
read the second part of our attendance code, which is the word home, HOME, and I've also put that in the chat. Um, okay, yeah, let me leave you to make these important concluding remarks. But then I can't help but ask too, what is the stumbling block from Milwaukee picking up the Madison schedule? Like,
Well, so
who would need to do that?
I mean, the thing is that it's not like the schedule itself is necessarily. How do I put this? It's not like it's directly flows from the statute itself, right? It's not
Yeah.
like it really is kind of its own thing. I believe
But it's
it
like
was the
agreed
Madison City
upon.
Council, right?
Yeah, okay.
I believe that's where it actually came from, was the Madison City Council. I could be wrong on that, but that is also the city level, because I know it doesn't apply to Dane County as a whole. It's Madison
Yeah, got
specifically.
it.
So, city officials might be the place to go for that. But at the same time, it largely has been applying to Milwaukee as is.
Okay.
Most of the commissioners and most of the judges are at least partially accepting the Madison abatement schedule as a good starting place. And that's really all it can be, anyways. Even if we had that from the city, I think that technically is correct, that it's only a starting place either way.
Yeah.
So, whether or not something's moderate or severe, that's
Mhm.
somewhat in the eye of the beholder, slash what evidence do you have? What proof?
Mhm.
So Yeah. So for right now, it is pretty reliable. It's not perfect. There's always risks. So as long as the tenant understands that. Um, Real quick, I just do want to go over this because I do think it honestly is maybe somewhat more important than all of the material that we've been throwing at you today. And sorry, we did throw a lot of statutory interpretation things at you, but the people that we are dealing with in this situation are dealing with their home is unsafe. Their home is causing them health problems. It's causing their children health problems. And this is their home. This is supposed to be the place where they are safest. Um, they are worried. They're concerned about their health, their family, and really, if they reach the point where they're debating abating their rent, that also probably means that they couldn't find somewhere to go relatively easily, right? I think some of the instinct is to be like, well, if the place is so bad, just move. That is not a reality for the people. Certainly, that legal aid is helping. I'm sure that the Marquette Volunteer Legal Clinic is helping too. That just move is not only not valuable, it really is counterproductive to what we need to be doing here. Um, they're dealing with mice, roaches, um, mold, ceilings caving in and hitting people on the head, um, people sleeping in plastics that way they don't get bed bugs. These are the type of issues that we're looking at here. Um, and not only that, but then they don't have a good way to deal with these problems, right? They they can't move. They can't afford to try to remediate the problems either, right? Extermination is expensive, and even if the tenant might or the tenant is entitled to this abatement, they are still putting themselves at risk of an eviction. So if people are angry and dealing with these problems, I it's important to kind of redirect, right? And come to these conversations with empathy, compassion, understanding, patience. A lot of people aren't going to have good documentation or what you want. That's okay. Work with what you have and inform them on what is best practice moving forward and move on, right? Let them know, hey, this would be better, but this is what we got. So we'll work with what we got, but moving forward, this is what you should do. Inform your landlord in an email, whatever that might look like. Just keep that in mind whenever you're dealing with these cases. Um, Carolyn's question that spent many money trying to remediate a problem. Um, that's a good question. It in general, I have been able to basically, if the amount is, I've only done this with amounts that are under like $250-ish. I would add like the receipt to a filing, and the court would reimburse that directly, basically. They don't really question exactly how you get there. They just are like, yeah, that's abatement. I don't know that that's technically right. I think it actually is technically more of a contract claim. It gets really weird if you want to get bogged down in it. Um, I would just reduce it one time. I would just say in the letter, I am reducing my rent by $100 because I had to pay for traps. I'm doing it for this month, even though it was in a previous month. And then you don't do it again moving forward, right? Because it's a one-time thing. So that is what I would do. Again, we're always getting into best practices here. It's a tough situation because there's not a lot of ground here, which is honestly a lot of the reason why we relied so much on the statutes here is a lot of uncharted territory. Best practices is what we've been talking about. Document, inform the landlord, inform the landlord, inform the landlord, and then reducing the rent based on that. But that's really what we're trying to do here is try to make this more of a thing and basically try to um, make the landscape better, big picture for all of these tenants.
Thank you both so much for your time. I think the number of questions really drives home how commonly we probably do see this in our legal clinics. And I know obviously you do on a daily basis as well. It also drives home, though, how important it would be for somebody to have a lawyer to walk them through these things. Because It's not the most complicated material any of us have ever dealt with, but it certainly isn't the simplest. And there are these just little pathways that it seems like someone can take, but nothing that a tenant who hasn't attended numerous CLEs of this sort would know. Nobody would know this. And of course, that's the job of us as lawyers. So thank you both for doing it so tirelessly and for teaching us some of what you know today. Thanks all for attending. I'm going to stop the recording now, and people are welcome to pipe up if they have anything they want to bring up from here.